Welcome back to another edition of legal terms. These are legal terms that begin with the letter I. Identification of Criminals Act is a federal statute that sets out the right of police to fingerprint, take photographs, and collect information on accused persons of criminal offenses. If something is illegal, it's prohibited by law. It means that it also could mean that it's illegitimate. I'd refer you to the term, the Latin term below, to explore on this topic a little bit further. The term impute means to assign to someone or to attribute to someone. In family law, when a judge finds that the amount of income a parent discloses is not accurate, the judge may attribute income or additional income to that person, all for the purposes of calculating child support. See Section 19 of the Federal Child Support Guidelines for more on this topic. In camera is a term that's used to describe something that's private or closed, usually closed to the public. Said set of hearings that are not open to the public or media. See Section 486 of the Criminal Code for further on when a judge or justice can exclude persons from the criminal courtroom. Incarceration typically refers to when someone is incarcerated for a sentence, but this is also not to be minced with when it comes to pretrial custody, when somebody could be a prisoner or a person that is in custody of the state or in the police because they are awaiting trial. Indictable offenses are more serious criminal offenses that carry longer maximum sentences and higher fines. These offenses are also subject to more complex court procedures, including the right to have a preliminary hearing before trial in the Superior Court of Justice. This is on the opposite end of the spectrum of summary offenses. So summary conviction offenses are less serious offenses, and I'll get more into that when we talk about offenses. Although there are more offenses than I've noted here, summary and indictable offenses. Summary and indictable offenses are in the criminal spectrum. There are other types of offenses, though. The indictment is a formal document containing the indictable offenses upon which an accused will be tried. Indictments are used in the Superior Court of Justice. If you are facing a summary offense, then you won't be hearing the word indictment at all. Although, for hybrid offenses, an offense that could either be an indictable offense or a summary offense, you may hear that term thrown around before the Crown elects on how to proceed with the charge. An information, on the other hand, is a formal document containing the offenses that the accused is charged with. Informations are used in the Ontario Court of Justice and typically for summary offenses, although when a charge starts out, it starts out on what's essentially referred to as an information. That is in this criminal spectrum of documents. You can also see in provincial offenses, offenses starting out on an information. Also in the criminal spectrum, you can see a peace bond application be issued on an information. And essentially, it just contains the particulars of the crime, when, where, essentially what happened, and the charge information. An injunction is a court order requiring someone to do something or to refrain from doing something. Now, there are many types of injunctions that I'm not going to go into in this video, but a superior court or a federal judge is required in Canada to make one of these orders. You can't get an injunction if you're in family court in the Ontario Court of Justice or in the provincial court in other provinces. And if you're in small claims court, a small claims court or a court judge or a deputy judge in small claims court can't issue an injunction as well. This comes with the territory of federal judges being able to give what's called inherent jurisdiction or inherent relief, common law relief, if you will. An inquest typically refers to an inquiry held by a coroner or medical examiner regarding the death of a person who died in circumstances set out in the Coroner's Act. That is the Coroner's Act here in Ontario, although there are similar legislations across Canada. An inquest or an inquiry is essentially, looking to discover what happened. And typically, in an inquiry, there is a body of persons or a jury that will be put together that will decide on the circumstances set out by the medical examiner. Now, typically, it's not a trial, although it can be, for some very limited purposes, there can be some cross-examination if there is leave of the coroner or permission of the coroner. But typically, witnesses aren't cross-examined in these inquiries or inquests, and it is more for the judge to decide whether or not there will be some kind of interference like that. Only, in limited circumstances, as referred to in Wolf versus Robertson, a 1961 case, will there be some sort of intervention if the judge or the court feels that there's some sort of deliberate suppression of the facts going on. Insolvency is the inability of one to pay debts as they come due. And someone who is insolvent means that they are someone with at least $1,000 in debt to creditors, and they are unable to pay his or her obligations back as they come due. An interest rate is the percentage that a person owing money must pay to a creditor or recipient for the period that the money owed is outstanding. The criminal interest rate is the interest rate above the maximum rate allowed under the Criminal Code in Canada. Prejudgment interest rate is usually a term you'll see in civil lawsuits, is the rate at which interest will accrue from the date the cause of action arose to the date of the order. Post-judgment interest rate is the rate at which interest will accrue for money owing under a court order. So once the court issues an order in favor of the person receiving a judgment or an award, including costs, is calculated from the date of the order to the date of the payment. An interim or interlocutory order is an order that's valid for a specified period of time or until there is a final order. It does not finally dispose of the case or claim before the court or tribunal. The INTERJURISDICTIONAL SUPPORT ORDERS Act of 2002 is an Ontario law, and it can be found in pretty much every province in Canada, and it sets out the process for enforcement of a support order where one party lives in Ontario or another jurisdiction and the other party lives elsewhere in a reciprocating jurisdiction, sometimes even in U.S. states. Interrogatories in civil actions are a pretrial discovery tool for parties in which written questions are served onto the other person and which there must be a formal answer in writing in response. This is a sample of an interrogatory, and this comes from the family law rules here in Ontario. This is called a request to admit form, and this is used in family law to essentially ask the other party questions, and I'm going to show you a sample of what that would look like. So once all the party names are filled out up above, and the file is filled in, then the person would, put in here, this is the question for the other party that I'm looking to have answered. The child lived with the mother between 2007 and 2008, after which the child began living with the father. So why would someone do this? Well, it would be used as a tool to narrow the issues, and typically these answers can be used against another person.
in this specific document, you can also ask the other party as to the genuineness of a certain document. And in this example, I'm putting the doctor's letter of June 16, 2014. It is a copy of the let's say, Dr. Smith's letter of June 16, 2014, and you also must attach a copy of that document with this request to admit form. So this is sent over to the other side or the other party, and now they have a period of time in which they have to respond to it. If they don't respond to it, then essentially it's admitted that the documents are genuine and the facts that you're asking the other side are true. And this is the response form. So after you fill out all the parties, then you would fill out whether or not you admit that the following facts are true or the following documents are genuine. And you could deny specific paragraphs of the request to admit form. Again, interrogatories in a civil matter are used for refining issues and narrowing the issues. So I'm going to respond now to the other side, to Mr. Smith. I'm going to deny that the child lived with the father in 2008 because the child lived full-time with myself. And I am going to, so I'm only filling out these spaces. The document appears to be altered as the doctor's office logo and address are missing. So there has to be genuine reasons for you to deny the genuineness of a document. And you have to essentially state the reasons. Intestate is when one dies without having made a valid will. An issue is a single or certain point or fact or law disputed or at issue between parties to litigation, generally composed of an affirmative assertion by one side and a denial by the other side. So if I were to take an interrogatory or a request to admit, I would try and refine the issues of the case. Therefore, I'm trying to reduce the amount of conflict there will be at trial or dispute at trial. Thank you again for watching. This video is brought to you by the Federally Incorporated Self-Represented Litigant Society. We are a help center run 100% by volunteers, and I hope that you get onto the website, irepmyself.com, where you can find very soon a PDF document of all of these legal glossary series videos in PDF form. Thank you again for watching, and stay tuned for the next video very soon.